Hello and welcome to episode 58 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away this week. In today's episode, I'm going to tell you about a case headed to the Supreme Court about whether the charter requires the Quebec government to give taxpayer subsidized daycare to unrecognized asylum seekers.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about a new Supreme Court ruling that upheld air passenger compensation regulations, which is really just a veiled excuse for me to complain about WestJet and the regulations that enable our Soviet-style air transportation system. So the decision is called International Air Transportation Association of and Canada Transportation Agency. That's a mouthful. And it was a challenge by the global airline industry to the automatic compensation rules that airlines have been required to pay passengers since 2019 whenever your flight is delayed or canceled or you're denied boarding for reasons that are within the airline's control. And the industry's argument was that the CTA couldn't make these regulations without violating what's called the Montreal Convention, which is international law that Canada signed on to that provides for a universal set of rules about how damages claims against international air carriers are supposed to be handled. And the key question in the case was pretty simple. It was whether regulations requiring the airlines to pay these fixed amounts every time you face a delay or a cancellation count as, quote, an action in damages, in which case they can't conflict with the Montreal Convention rules. But according to the decision, the Supreme Court says these regulations are not actions for damages because they don't provide individualized compensation after showing harm. They're instead just a consumer protection scheme that fixes amounts when certain events occur, regardless of whether there's been any harm proved. So to be fair to the airlines, I can see some merit to both sides of the arguments here. I can see why they fought this in court. On the one hand, it does seem to be providing for damages in the sense that, like, why else would you be being compensated if you hadn't suffered some damages? But on the other hand, it does look pretty different from like a normal tort action for damages, as that's commonly understood. And I can actually give a pretty good example of why it makes sense to not really view these as damages, since you get the money even if you don't suffer damages, and you often suffer damage but can't get money through these rules. So recently I was on a Porter flight to Ottawa, and it was so windy that they offered first $400 to get off, take a later flight and lighten the load. Then they offered $800, which I almost took, but I did not because I had a commitment that evening, and this turned out to be a mistake. So I got on, I flew to Ottawa, which is an hour. We then spent like an hour circling Ottawa airport, like you literally see the airport, but we weren't allowed to land, I guess, because of the wind. And we flew back to Toronto, which took another hour, refueled, and then flew back to Ottawa. So it was like a 4-hour plus 1-hour flight I could have just driven in that amount of time. So
if going to Ottawa wasn't a punishment enough.
Yes, I know. It just added to my pain and suffering and general loss of enjoyment of life. But I got no compensation through these rules because it's not how they work. And people who got the $800 actually were better off. They got to Ottawa probably around the same time as me, and they were like sitting in the airport comfortable the entire time that I was on a tiny plane going back and forth. So interestingly enough, the CEO of the airline, Christine, his name's Robert Dehaas, I recognized him from like the in-flight magazine, and I told him I still thought it was better than Air Canada, even though it took 4 times as long, and I maintain that to this day. I also think Porter is better than WestJet, which is my real reason for talking about this story today. I'm still mad at WestJet. And, I realize this is kind of a first world problem, but I still think what happened represents something that a lot of us go through, which is bad service from our oligopolistic airline industry and the politicians who facilitate it. So, as you know, I recently went to Japan, and This was partly a gift for my partner's birthday. And so I wanted to make it nice, and I bought premium economy seats instead of the regular seats because those are for peasants. And I'm just kidding. As
It's
you know,
the only thing
Christine.
I fly.
Oh, really? Yeah.
Basic rate,
Oh, yeah,
basic. Not
yeah.
I don't even go standard.
No, I'm the same. I usually take economy, usually basic, but I want to make this trip special. So the premium tickets were 26.77 each, which is more than double what like the economy tickets normally are. Like they were 1150 if I recall correctly. And you're supposed to get, a bigger seat, which is really nice if you want to sleep on the plane. Your seat reclines, you get like blankets and pillows and meals and drinks, and you get to skip all the lines, including security, which is probably the best part. Um, so the morning of our flight, which was at 8 a.m., we were woken up at 4 a.m. by text messages from WestJet telling us that like the first leg of our trip had been canceled, which was Toronto to Calgary. And we had two options. One was fly a later flight that morning in economy, despite having paid twice as much, and or cancel. And so obviously we took the economy, and I got squeezed into like we both got squeezed into these middle seats. I was between two men like this, like when you're 6'2" and there's also like 6'2" people beside you, you just like are squeezed together like to use the cliche a sardine. And this was a big problem for me because I had planned to like work on that flight, and I like had this, 4 hours of work. I was like, it's a 4 hour flight. I'll just do that with my laptop since I'll be in premium economy. But no, I was not able to do that. And to make matters worse, there was like a entire row beside me with one single WestJet employee sitting there with aisle seats available that I could have sat in. But anyway, they told me that those didn't exist. So after like a month of forms, emails, phone calls, it turns out that the compensation I'm going to get for this is $99. And that's because their contract states that despite you paying more than twice as much, if they decide to dump you into a middle seat in the back, they're going to refund you 40% of the basic fare. So not 40% of what you paid, but 40% of what like the lowest, seat cost would have
The
paid. So
basic rate, what I usually get.
yeah, the Christine Fair. Um, so I know it's not a big deal, like whatever, like WestJet
I
stole
pay
hundreds of
math.
dollars from me, but technically it's in their contract. But everyone I know has these stories, and I read one in National Post recently that's even worse than my own, like far worse. And it's this family of three that flew from Hawaii to Vancouver. Well, they bought tickets from Hawaii to Vancouver, but the airline, because of some smoke, decided to divert to Victoria, which is not Vancouver. And they said you have two options. You can wait till tomorrow, like sleep in the airport or pay hundreds of dollars for a hotel and go tomorrow from Victoria to Vancouver, or you can get a refund and we'll process the refund later and figure out how much we owe you. So they chose refund. When WestJet calculated their refund like a month later, because they do it like weeks later, they offered them $16.17 refund to get from Victoria to Vancouver. So this was their logic was you made it like 98% of the way home from Hawaii. Never mind that there's like an ocean in between or that costs hundreds of dollars to get from Victoria to Vancouver. So anyway, these passengers fought this. They went to BC's Civil Resolution Tribunal and they actually got $2,000 in compensation, which is pretty nice. But most of us don't have the time or the energy to do that, and the airlines know. So what's the solution to these horrible airline policies? I don't think necessarily it's going to courts or tribunals or more regulations, although it is nice to have those automatic compensation rules. I think the real answer is fewer regulations. Like if foreign airlines were able to operate between Canadian cities, which they do in Europe, throughout Europe, and obviously in the United States, then we could have a lot more competition. We could have US airlines flying between Calgary and Toronto. And when there's more competition, it's funny how it works, but magically that tends to lead to better customer service since you have somewhere else to go if airlines treat you badly. Another big problem is we have foreign ownership rules that I don't think there's any logical reason for that says foreigners can't own more than 49% of an airline in Canada. And That's a problem because it takes hundreds of millions of dollars to launch an airline, and there's not that much capital in Canada. Most capital in Canada is fleeing the country right now, right? So you're not going to see new airlines launch if you don't change those rules. Then there's all the taxes. Like Montreal Economic Institute has written about this, and the fuel tax in Canada is more than double the fuel tax in the United States, and that's before you add on the carbon tax, and that's before you add on the world's highest airport fees, which clearly don't get us the world's best airports. And so the taxes also need to come down. And the airports, if you ask me, need to be privatized. Lots of countries have this, and they seem to have better functioning, more affordable airports with lower fees. So anyway, I think obviously the airport unions, WestJet, Air Canada, they'd all throw a giant hissy fit if you tried to, modernize and fix this industry that's clearly broken. But I think it would be worth it for a politician to do that. So Pierre, if you're listening, put this on the list. Christine, thanks for letting me vent. Do you have any horrible airport stories, or is it just me?
You know what? I'll tell you a story and it will make you upset because of how good my story is. So I went to London, England with my family, I guess 2 summers ago, and it was just post-pandemic. Like everyone, the airlines were like now flying normally again. You didn't have to go through all the rigmarole of getting tested, blah, blah, blah. But because the airlines had just reopened, everything was like a hot mess. And flights were getting canceled and like everything was getting lost and people were getting sent to the wrong places and people would have to sleep in airports. And we have 3 kids and we didn't want to have to deal with that. So we bought flight insurance. Like we bought like a small policy that covered the whole family, or we bought policy for everyone in the family, something like that. It was like not that expensive. And we went to England. It ended up being fine. But on our last day, we were coming home and we had like an afternoon flight and we got a notification in the morning that our flight was going to be like 8 hours delayed, which then triggers the air passenger protection regulations. And because we're in Europe, they actually like are really strict about it when you're flying out of Europe. They really, because I think you could bring a complaint in Europe as well, where they really give good benefits to passengers. So I think we ended up putting in we started our insurance claim. We said, oh, our flight is delayed, it's delayed 8 hours. So we got like this huge amount of money from the insurance to cover all of our expenses for that day, which we used on going out to eat fancy Indian food, because the best Indian food in Europe is in London. It was amazing. Like we had the most amazing day. We went to Camden Market and bought like little souvenirs. We like spent the amazing day in London eating Indian food. Then we went to the airport at the same time like that the airline had told us, which was later. It was like 8 hours later. So now it was like an evening flight. And then we got almost $5,000 in compensation from the
Wow.
airline for these tickets, which, by the way, we had purchased on points. So it was like a really great situation for me. So I'm sorry, Josh, but this kind of shows the weird way these regulations work. Like we bought these tickets on points. We actually got like a bonus day in London where our expenses were covered. We didn't lose out on anything. If anything, we gained a lot from this extra day and the insurance money we got to use on our food and activities. So why am I getting compensated? Meanwhile, compensated more than I ended up paying for the ticket. Meanwhile, Josh, who paid like this huge amount for a comfortable seat for a special trip to Japan and ended up being a sardine beside the bathroom, you get like $100. Like the whole system doesn't work in a functioning way.
Yeah,
And
maybe there are too many regulations. You never know. That could be impacting, the fairness of what I get is because they overpaid you, right?
me,
So yeah, maybe the
I mean,
better way is like the tribunal
it just
approach,
shows
but
like we can't do anything right. Like Canada, when we try to do these things, it's all a mess. Like nothing works the way it's supposed to. If our listeners do want to learn more about the case itself, because we're supposed to spend some time talking about the Supreme Court decision more than giving our own gripes about
That's the
Canadian.
whole decision. It's a simple decision.
Yeah, if you want to like do like a deep dive, I did do an episode. I did 2 episodes on my TV show Canadian Justice about it, so I gotta promote myself. So that's available on the News Forum's website. And I interview one of the interveners in the case. So let me talk about my news headline for this week, which, unlike the decision you just described, this is the opposite of a simple case. This is in what has been called the most difficult parts of Canada's constitution or Canada's charter by some judges. This is about Section 15. And I don't know if this is a difficult part of Canada's charter because it's inherently difficult or because the courts have made it so difficult. Probably the latter. So the case is called Quebec and Kanyinda. And Miss Kanyinda was an irregular border crosser into Canada. She came here from the Congo via the United States at Roxham Road. So already some issues there about the safe third party stuff. So let's set that aside though, or sorry, safe third country issues. So let's put that aside. So she was given a work permit when she entered the United States while her asylum claim was being assessed by the federal government. And while she was waiting, she had this work permit, she requested one of those Quebec subsidized daycare spots because she had 3 young children. And the Quebec government denied her that request for a taxpayer-funded daycare spot because they said that the program is reserved for people whose refugee status has already been recognized by Ottawa, not people like her who are still awaiting the federal decision on their status. So when her request was refused, she made a claim, a charter claim. She made a couple of claims. So the one I'm interested in is this charter claim that the policy is discriminatory and a violation of her Section 15 right to equality, because she said it has a disproportionate impact on her on the basis of her sex as a woman. And this is an adverse impact discrimination case. I mean, obviously, they're not saying women specifically can't have this, that it's a neutral law that she says has a disproportionate effect on women like her. So she, in making this argument, relied on a Supreme Court decision from a 2020 case called Fraser to make that argument. But the lower court in Quebec found that there was not enough evidence to make out a Section 15 claim. Now, this is a quote from a French translation, so it might not be perfect, but the lower court said there is no way of determining the proportion of the male and female asylum seekers who would bear the additional costs of looking after their children. The case of the applicant who arrived alone with her children cannot constitute statistical evidence. So that's Ms. Kanyinda, who arrived alone with her children. But then it went to the Quebec Court of Appeal and they overturned that. They found that there was a Section 15 violation and they cited the updated Supreme Court decision in a case called Sharma. And I think it's worth noting here that the jurisprudence on Section 15 seems to be in constant flux. Many have criticized the majority in Fraser for going too far with the notion of substantive equality and adverse impact discrimination. And while substantive equality has pretty much always been a part of charter jurisprudence on equality, its scope has expanded pretty dramatically and has been the subject of a lot of debate. In the Fraser case from 2020, Justice Abella, for the majority, stated that whether or not the lawmaker intended to create a disparate impact is irrelevant. As well, she emphasized that differential treatment can be discriminatory, even if it is, quote, based on choices made by the claimant. And Fraser permits the use of statistical evidence to prove all of this. The dissenting judges in Fraser disagreed with Justice Abella's what they described as a relaxation of the causation requirement between the law and the alleged disadvantage. And the dissent said that it's a dangerous lowering of the claimant's evidentiary burden to the point of potential insignificance. And they said substantive equality has become almost infinitely malleable, allowing judges to invoke it as rhetorical cover for their own policy preferences in deciding a given case. This discretion does not accord with, but rather departs from the rule of law. And some scholars have also criticized that Fraser decision and the Section 15 jurisprudence for lack of clarity, for being in that constant flux, and still others have criticized the entire notion of substantive equality from a philosophical perspective, describing it as little more than an argument for equality of outcome. That said, substantive equality has been part of charter jurisprudence, basically since the first Section 15 case. But I'll leave it to you, the listener, to determine where you land on the benefits of substantive equality in that philosophical debate. Now, Sharma came out in 2022, and it seemed to put some, I don't know if you'd call them limits, but it did have an impact on maybe the expansion, the potential that Fraser had for expanding that scope of substantive equality. And the court said that they were not changing the Section 15 test. Justices Rowe and Brown wrote the majority, and they said that they were clarifying the Section 15 test. Now, that Sharma case considered the case of a woman named Cheyenne Sharma. She was a First Nations woman with no criminal record, and she pleaded guilty to importing nearly 2 kilograms of cocaine that her partner had asked her to bring in a suitcase and promised her $20,000 to bring it to Canada. Now, the issue in Ms. Sharma's case was the constitutionality of a criminal code provision that made conditional sentences unavailable for her offenses. And she argued that as a First Nations woman, these criminal code prohibitions unjustifiably infringed her charter rights under Section 7 and Section 15. And there are these principles of sentencing for First Nations or Indigenous defendants called the Gladue principles. So that was at issue as well. But the majority in Sharma, the majority of the Supreme Court denied her Section 15 claim. They did note that there's a crisis of Indigenous incarceration that is undeniable, that there are more Indigenous people incarcerated proportionate to how much of the population they actually make up, of the general population. But they said Ms. Sharma did not demonstrate that those criminal code prohibitions that made her ineligible for that conditional sentence. They said that she could not demonstrate that they created or constituted a disproportionate impact on Indigenous offenders compared to non-Indigenous offenders. And she would be required to show this disproportionate effect at the first step of the Section 15 test, which she did not. So the Section 15, the first step of the Section 15 test requires you to show this disproportionate effect. They said she failed to adduce statistical evidence to show that those criminal code prohibitions created or contributed to a disproportionate effect on her as an Indigenous offender. And all of this, I think, the use of statistical evidence, I think, creates a problem in the Section 15 analysis. This reliance on statistics to prove things can really go a lot of different ways. I mean, what is that famous quote? It's like, there are 3 kinds of lies, damned lies, and statistics. And I think that can be an issue in a lot of these Section 15 cases. So it's coming up again now in this Kenyinda case about the taxpayer subsidized daycare spots for unrecognized or not yet recognized asylum seekers. And Ms. Kenyinda argued that in her case, the denial of that subsidized daycare spot for an asylum seeker who didn't have federal status doesn't directly target women like her, but it has a disproportionate impact on women, and that makes it discriminatory by adverse effect, since women, either if they're alone or if they're in a couple, they disproportionately assume the obligations related to the care and custody of children. And the denial of the daycare spot, therefore, constitutes an obstacle to her integration into the labor market and more broadly, integration into Quebec society. And it's a disproportionate impact on women seeking asylum. And the Quebec Court of Appeal found that Ms. Kanyinda had met her burden at the first stage, demonstrating that the adverse impact on the ground of sex was shown. And part of what they relied on, they called convincing scientific evidence in support of her arguments, in particular, the report of expert, a woman named Jill Hanley. And Ms. Hanley, I guess, had written these expert reports saying women do more childcare work. Now, like most Section 15 cases, this is a sensitive and emotional story, and I do feel for Ms. Kanyinda's children. The facts of these cases can often be difficult, and I think that that can actually contribute to why judges don't want to find one particular way, because they are swayed by the emotional nature of some of these Section 15 stories. And that leads to, I think, some of the mess around the Section 15 jurisprudence. Section 15, the lower court judge in this case called it the most conceptually difficult provision of the charter. And as I said at the beginning of this, I think that that is probably more because of the way the courts have treated this than because of the actual nature of Section 15. And it seems like the Supreme Court is like re-articulating or restating the test for Section 15 every 2 years. They did it in 2020 with Sharma. They did it in 2020 with Fraser. They did it in 2022 with Sharma. And now in 2024, they've given leave to this Kanyinda case that I think is going to be a further development in the Section 15 landscape. So I think that this is a case that I'm really interested in following. I have my own thoughts on the Fraser decision, which I do think has led to an unwieldy and ever expanding sense of what Section 15 actually does. And this could ultimately be to the detriment of the government's actual ability to develop and implement programs. If Fraser, an unlimited view on Fraser means that everyone must have access to every single program the government has, the government might stop having programs. And I don't think that that's probably what most of us want. But this is something that the majority in Fraser sort of alluded to. So, Josh, I don't know if you have any thoughts on this. This is a really difficult case emotionally and also conceptually. But what do you think?
I think I have a lot of thoughts, and I'll keep a lot of them to myself. But thinking back to law school and the whole idea of adverse impact discrimination, like obviously that's a real thing, and that comes in Canadian law from a case called Mayorin, and it was about a BC firefighter applicant who was a woman, and BC required applicants to, I forget the exact details, but they had to do some sort of fitness test, and they had to like lift a certain amount, which you didn't actually need to do to be able to do the job well. So, everyone was treated equally and that they all had the same test to pass, but most women they don't have the physical strength that men have. And so this was arbitrary. It was, an arbitrary requirement that did, impact women in a way that it doesn't impact men, and kept them out of the profession for an arbitrary reason. And I think that's the key to all this Section 15 stuff. Like, some people view Section 15 as we all have to end up in exactly the same place, which is not what anybody possibly could have meant when they were, writing the charter in 1982. That's like that's sort of a fantasy world, a utopia that doesn't exist and never will. But The real reason we have it is to prevent arbitrary distinctions that lead to discrimination. So I think I'll leave it at that. Maybe we want to take a break and then do our BLTs.
Sounds good.
Okay, I'll go first with my BLT. Mine goes to climate justice, Saskatoon, and the activists who were in court this week arguing that the Saskatchewan government, Sask Power, and the Crown Investments Corporation of Saskatchewan are violating their constitutional rights because, checking my notes here, they built new gas-fired power plants so that people don't freeze their asses off in winter. This claim is based on Section 7, which is protection of life, liberty, and security of the person, and not to have that interfered with except in accordance with the principles of fundamental justice. And the argument they're making is that the government's policy creates greenhouse gas emissions, that this will kill people and impact bodily integrity because climate change. And this is obviously just such a huge stretch because the actions of the government are so remote from anyone's actual life or bodily integrity, not to mention that electricity generation actually sustains people's lives rather than killing them. Not only that, natural gas actually arguably reduces climate emissions in Saskatchewan because the alternative available at the time was coal, which is much worse. Anyway, this week's hearing was the government's motion to strike the claim, which only happens if it's plain and obvious the applicants don't have a cause of action. And I don't know what'll happen, but I do think it's plain and obvious that Section 7 doesn't protect you from every butterfly flapping its wings in Japan or every policy that you don't like, to say nothing of the policy we just talked to in the previous segment. And I just think these people are kind of delusional about the impact that they can have on climate change because, yeah, climate change is a problem. We should do what we can, but Canadians produced 1.4% of global emissions in 2021, which is actually way down, so good for us. But, we could disappear tomorrow and climate change would be unaffected because we're such a small population. And Saskatchewan is only 10% of Canada's emissions, so it's like 0.14% of global emissions. So anyway, I hate activists wasting court time like this. I think if you disagree with building gas-powered plants, you should go to your politicians, you should write about it, but you shouldn't waste court time. So Christine, that's my BLT. Let's hear yours this week.
So my bad legal take goes to a few people who are not getting along. First, it goes to Niagara Regional Police. Then it goes to immigration and refugee lawyer, a woman named Joanna Baron. And then it goes to 10 people who complained about Joanna Baron and her posts on LinkedIn that are critical of Israel and supportive of the cause of the Palestinian people. So I learned about this because someone had posted a video recording of an interaction that Joanna Baron had with Niagara Regional Police on October 2nd. So the police came to Barry's house to warn her about her social media posts and messages on LinkedIn. She'd been posting pretty emotional, let's say, things about Israel and the conflict in Gaza, critical of Israel and supportive of the Palestinian cause. And honestly, I don't agree with her takes on Israel at all. I think that they are they offend me. I think that they are gross posts, actually. But she's entitled to her opinion about Israel, as we all are. And the thing is that the police coming to her house to talk to her about it, that is really disturbing. So it seems like, based on watching this video and doing a deep dive into the things that Barry posts on LinkedIn and posts on X, it seems like the Niagara police were sent to her house on the basis of some complaints by other lawyers, and they were sent there at the request of the Ottawa police. So the police these were detectives, so high-level police officers, actually. And they told her, she filmed it, she didn't film their faces, but they told her they were there to talk to her about the things she'd been, quote, putting on her social media. And first, the police said that the complaint was because of the Law Society, which doesn't make any sense. And then they said it was a complaint by 10 lawyers who are Jewish. And they said that her posts are, quote, walking the line. Now, Barry responded to this. She said that this is an escalation of fascism. I think that that might be hyperbolic, but I agree that it's highly disturbing for the police to come to your house to talk to you about your social media posts. And she said criticism of Israel and Zionism is not anti-Semitic. She said that her spouse is an anti-Zionist Jew. And she said that this is like a dystopian novel and it's Orwellian. I do agree with that sentiment, that the police showing up to talk to you about your social media opinions on a foreign conflict, that is Orwellian and dystopian. So she said, she asked, what is the criminal complaint? What is criminal here? And the police said it was, they were there to talk to her about unwanted messages to lawyers on LinkedIn. And they were there to, they said that they were there to have her stop messaging people on LinkedIn, which is crazy. Like, if you don't want someone messaging you on LinkedIn, but like, you can block them on LinkedIn. Perhaps, I don't know the full extent of what she was doing. I did go through her posts. As I said, it just seems like a kind of hysterical person who spends too much time online and uses LinkedIn in a kind of weird way. I mean, most of us use LinkedIn to post about job opportunities or like post our resume or our professional accomplishments. We don't use it to comment and repost. One of the things she seemed to be doing was taking screenshots of things that people had liked about Israel. Like, for example, someone had reposted or liked a meme about the Israel's blowing up of the pagers in Lebanon, and they posted like a Roadrunner meme that said beep beep, and they liked that, and she thought that this was appalling, and screenshotted that and posted it, which, like, I kind of find that funny. Like,
It's
sure,
funny.
it is funny. Like, she's deeply offended by that, but like, that's also not criminal harassment to repost that. I will say, I don't know, maybe it is like criminal harassment exists, and I don't know all of the facts here. I suppose it is theoretically possible that she was sending lots of messages, doing something criminal, but I do think that doesn't seem to be the case here. The police probably would have mentioned it. And also, we now know that the 2 criminal complaints against her, those have been closed. She posted this last night. So I am on her side on this. Like, I do not think the police should have to come to your house to talk to you about your social media posts. If you don't like someone's posts on social media, if you don't want them commenting on your stuff or private messaging you, you can just block them or just ignore them. The comments alone do not rise to criminal harassment based on what I saw. So there was also, it seems like, a Law Society complaint against her, or 3 Law Society complaints against her. Those also now are closed. I find this all like deeply disturbing. I'm giving this bad legal take to the police and to the people who complained against her, because you should not weaponize the police to go after people who disagree with you about an international conflict. This woman is entitled to criticize Israel. She's entitled to criticize other lawyers who support Israel. I disagree with her criticism, but she is entitled to it. And I'm very disturbed by the police coming to her house to talk to her about it. That is an extremely intimidating thing to do. So my bad legal take goes to the police. It goes to the people who complained about her, but it also does go to this woman, Joanna Baron, in part, because her reaction to the police as a lawyer was not great. She got really upset, and I would say hysterical. She started crying and shouting at the police. And look, I do understand why this is upsetting. She's entitled to be upset, but as a lawyer, that is not effective engagement with the police or effective advocacy, especially if you're planning on recording this and putting it on social media. Now, she did allude to that in her post. She called it, quote, not her finest moment of eloquence, but that she was so unbelievably angry that that's what happened. Okay, fine, but I'm still going to give her a bad legal take because I disagree with her post on Israel, even though they're not legal takes. and because she reposts some of our bad legal take favorites, like Heidi Matthews from Osgood and Joshua Seeley Harrington from, I think, Windsor Law now. She reposts them on the regular. Those are just reposts of bad legal takes. And I'm also giving her a bad legal take because she said she suggested in her most recent tweet that now she might sue the people who complained about her to the police and the Law Society. Like, I don't think that is a good idea.
Come on.
Like, you can't, I don't think you can do that either.
Look with that.
Bad legal takes all around, but I'm more, like, frankly, I'm most disturbed by the police conduct here. So that's mine for this week.
All right, thanks, Christine. You did like a triple bad legal take since Joanna's away. That's the end of the show. As usual, we hope you'll rate us, review us, and subscribe. And you can support our work by subscribing to our YouTube channel, by following us on Twitter, or by visiting the ccf.ca, where you can sign up for our Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please do click that blue donate button on our website if you can. Thanks for listening.